Hi, this is Irina Shea. This is part of our Wealth and Wisdom series. Today, we're going to talk about, do I really need a trust in New Jersey? And this is a question that gets asked of us quite a bit by clients who are confused because there are many different kinds of trusts for different purposes. So today, we're going to talk about revocable living trusts and whether they're needed in New Jersey. And we actually have a checklist because enough people have asked us. And so I'm going to walk you through that today by sharing my screen for a page on our website. So if you'd like to follow along, you can go right here to our website, and we're going to go right to this drop-down menu, Revocable Living Trust Checklist. And what this is, it's a little analyzer to determine if it's necessary. For many people, a straightforward will is enough, but for others, a revocable trust is better for various reasons. So, the discussion's usually around probate. Okay. Probate is a very straightforward process in Bergen County, New Jersey. It's a one-page probate petition, a $200 fee. If you're unfortunate enough to die in New York, your kids will have to deal with New York probate. That's really difficult. So, if you have a relative in New York or you live in New York, yes, revocable trusts are very common standard practice. In New Jersey, however, there are other reasons. So, what are they? If we are creating lifetime trust for your children that silo assets for divorce protection, creditor protection, et cetera, and make sure money stays in the bloodline only for your children and grandchildren, then yes, we want to use a revocable trust to avoid what are called testamentary trusts that are overseen by the local courts for the life of that trust. Okay. Another reason is if you are a solo senior and you don't have children and you're leaving assets to siblings, nieces, and nephews, there is a New Jersey inheritance tax. There are tax waivers and a whole lot of red tape associated with that. A revocable trust greatly mitigates it. Okay. Third good reason is if you own out of state property. A lot of people have a condo in Florida or South Carolina or just somewhere outside of the state of New Jersey. If that's the case, it's best practice to be sure to avoid what's called ancillary probate in that secondary state. So that you definitely want to have titled in a revocable trust or otherwise deal with it as joint or payable on death deed. It's more nuanced discussion, but this is one good indicator for when a revocable trust is useful. Okay. Reason number four, incapacity. Unfortunately, that's just a reality of people living much longer than they used to. There's often some time period, weeks, months, or years of incapacity. If you have a revocable trust, you can bundle all your assets into it, real estate, brokerage, bank, everything basically but retirement plans, and have an adult child co-manage it with you or for you. So that's very important as we age. Fifth reason, will contests. If you are disinheriting a child, that's a very difficult decision to come to, but you definitely want to then create barriers to a will contest. And one of the barriers, and there are several, is a fully funded revocable trust. Okay. Six is privacy. If you have any notoriety or privacy concerns, the Rev Trust is private, not filed publicly. And number seven, flexibility. It's very easy to amend these, easier than a will, fewer formalities, more notary and less witness. So that's not a bad thing. And number eight, powers of attorney more than 10 years old often get scrutinized by banks for good reason. There's a lot of elder financial fraud. So um, it's just a trust is just stronger than power of attorney. If your child has to go to the bank with power of attorney, they're going to scrutinize it, make sure it's up to date, and go through a little more compliance. If, however, your child is a co-trustee with you, if you're older, that trustee actually has ownership access, not agent access. It's a higher level of authority over assets as we age. Okay. And then charity, if you're leaving assets to charity, try to do a flat dollar amount. But if it's going to be percentages, for example, clients who don't have children often leave money to charity in percentages. It involves the New Jersey Attorney General Charities Bureau. It gets into a whole lot of accounting paperwork. It helps tremendously if you utilize a revocable trust for that to cut down on all of the compliance. Um, 10 is portability. If you're about to move to Florida or New York and you know they use revocable trusts there, you might as well just set one up now and be ready to go. You still would have to amend it in the new state because Estate planning is state-based law, but you'll be one step ahead of the process. Okay. And then 11, accumulation trust. If you have minor children ages 10 and 12 and you're leaving IRA assets to them, there's going to be a significant delay in payout. We can instead direct that to accumulation trust for those children until they become 21 plus. And that is done under a revocable trust. Okay. 12, we already touched on. New Jersey probate is easy. New York is difficult. So depending on the state in which you're living, that could tilt one way or the other. So when you clients meet with us in the office, we do this analysis and we try to determine what's best and when and why. It is not one size fits all. So if you'd like to learn more, please go to our website at irinashea.com. And there is a Get Started Now page right here. And you can click if you'd like the type form and start a consultation process. There is no charge for our consultations. Thank you so much and hope to chat with you.